Good morning, everybody. Hi, my name is Simon King, and I'm the National Business Development Director at Freeze. I hope you're all well, and thank you for joining us this morning. On behalf of Freeze, I'd like to welcome you to the sixth in the series of the Coronavirus Hub webinars and the first in our Future Workplace series. On our panel today is Daniel McNally from our regulatory team, Fiona Powell from our employment team, and Luke Dixon from our commercial team, who specialises in data. I will be passing you over to a panel of experts shortly, but before I do, just wanted to confirm that there will be an opportunity to submit questions during the talk, although many of you have submitted beforehand, which is good for us, but we'll try and answer as many as we can at the end of the session. You're able to submit your questions through on the Q&A function on Zoom. We will endeavour to answer all your questions, but those that we can't, we will come back to you independently over the next few days. Now, I'm pleased to pass you over to Daniel McNally to kick us off on the health and safety implications on the actual return to work, how and when. Daniel, over to you.
Thank you, Simon, and good morning, everybody. As Simon's helpfully said, I'm a regulatory lawyer here at Freeze, and I'm going to provide you with a very quick update from a health and safety perspective. As more and more of us are returning to work, one of the questions which I'm often asked is, how does health and safety law actually apply to COVID-19? Well, it's a very interesting question. If you listen to the government and the health and safety executive, they would argue that the position is very clear and that employers are under as much a duty to safeguard their employees against the risks presented by COVID-19 as they are from any other risks in the workplace. And the health and safety executive have actually come out and said publicly that any companies who are failing to meet their obligations in this regard will face enforcement action, which could range from anything such as words of advice through to the service of enforcement notices. So whilst that might be the message from the government and the health and safety executive, there are those, including myself, who would question whether health and safety law does actually apply to COVID-19 in the workplace. And I say that looking at the Health and Safety at Work Act, which came into effect in the 1970s. And I asked myself the question, was it really Parliament's intention that this legislation would apply to something like COVID-19, which is not a workplace pathogen. It's not an occupational disease which is limited to the workplace. It is a public health issue. It's much wider than the workplace. And I think when you look at it from that perspective, it does raise some serious questions there regarding the applicability of health and safety law in this area. And in my own personal opinion, I think we are dealing with a situation where the government and the regulators are using health and safety law and overstretching it beyond what was ever intended by Parliament. Ultimately, the question of whether health and safety law does apply in the workplace is something which I suspect will be litigated in due course if the Health and Safety Executive ever decide to prosecute anybody under the Health and Safety at Work Act. Having said all of that, as we sit here today, it is my firm view that employers should assume that health and safety legislation does apply, because frankly, the risk of not doing so at this stage is too great when you think about the possibility of enforcement action and the possibility of prosecution. So, notwithstanding my concerns about the applicability of the legislation, for the time being, employers should proceed on the basis that the legislation does apply unless they are told otherwise. And that being the case, employers, of course, need to focus on making their workplace as COVID secure as possible. So that's the current position from a health and safety standpoint. And I'm now going to pass you over to Fiona, who's going to talk to you about current issues facing employers from an employment law perspective.
Thanks, Dan. I'll just say at the outset, I know somebody's just put in the chat box that are we muted? As far as I'm aware, the sound's okay, but if anybody is struggling with the sound, then obviously do let us know in the chat box. So from an employment perspective, obviously there's been a whole host of issues arising from the pandemic, lots of challenges that employers are now facing. And for different businesses, of course, the landscape has been very different. Some have been completely closed during this period and are now reopening, getting used to the legislation, the guidance and preparing. Others have been operational throughout and are more used to that and have adapted to it and are moving with how the legislation changes. And of course, then we've got some employers looking at, they've had to furlough, they've had to change terms and conditions, they're potentially looking at redundancies. So the employment landscape is one of a changing pattern, and that is going to continue to change. So businesses really need to be adaptable and be very flexible, because that's the picture going forward. It has changed and it will continue to change. So businesses need to be looking at the future workforce, what it's going to look like, how they prepare for it, what the restrictions apply, how they're communicated, and clearly, complying with health and safety, data protection, and considering employment law aspects. I think the key piece is that employee relationship and the communication piece. That is key, because if your employees are anxious about returning to work, if you can alleviate those concerns, show them that you're being very stringent in your processes, that is in turn going to ensure that the workplace it goes back into smooth running, but it also will transfer over to your customers who can see that your employees are calm being back at work and that you've taken the necessary steps. So depending upon the approach that your business takes, taking into account the sector-specific health and safety guidance, a lot of businesses are then thinking about, right, I've done my risk assessment, but what about face masks? What about testing? Are these things that I should be doing? Can I do it? What if an employee refuses? And that's what we're seeing coming through now. And that's some of the issues that we want to have a discussion about today. And that lends, and I'll hand over to Luke now, it lends onto Luke's area, data protection, because once you've then got that information, what are you going to do? Luke, if you can hand over.
Great, thanks very much, Fiona, for that. Good morning, everybody. Thank you for your time. I hope you find this enjoyable and illuminating. First thing to say is, from my perspective as a data specialist, is that yes, GDPR and data protection very much potentially applies to this area for employers and businesses. And the reason for that is that GDPR, as you probably know, is the legislation which regulates the processing, so the use and collection, sharing of personal data. And in scenarios such as workplace testing, an employer would be collecting and using and potentially sharing personal data of employees, but what is more, they would be collecting and using, etc., health data, COVID data of their employees as well, which is also regulated under GDPR. It's important to add, though, that despite its reputation as being a highly obstructive and quite painful piece of legislation, GDPR, the Data Protection Act 2018, will not, it's not intended to stop employers from being able to do things like testing. It's just a matter really of testing and processing the data in a way which complies with the requirements and the principles of the legislation. And so that's really what employers should be thinking about when they're collecting COVID data, doing employee testing, etc. So in terms of the main principles and themes that employers need to be thinking about, the first is whether they have a lawful basis under GDPR or the Data Protection Act in order to process the data for their purposes. So they might, for the regular personal data they have, they might be able to use, for instance, their legitimate business interests, if they can justify that in the circumstances. where they're processing the special category health data. They might be able to use, for instance, their obligations as employers to ensure health and safety in the workplace. In addition to that, it's very important for employers to be transparent, to be open and honest with their employees about how they're processing the data. And they can do these kind of things by giving the employees appropriate privacy notices, giving them good detail about what precisely they're going to be doing with the data and why, what the lawful basis is, etc. So that's another practical step to take. Also important for employers to bear in mind what we call data minimization, which is basically not collecting or using any more data than is strictly necessary for your purposes. So if you can keep the amount of data low that you collect, you just use it strictly for your own purposes, say for testing, not only will it abide by the principles of GDPR, but it would also, because you're collecting less data, just minimize your exposure to any potential problems under the legislation as well. Clearly, some of the data that you may well be collecting, the health data, for instance, will be sensitive. And as such, you also need to bear in mind the importance of applying appropriate security measures to the data that you collect. Nobody wants, particularly in this atmosphere, to be in news websites on the front pages or in the business pages for having experienced a serious data breach of their employees' COVID-19 data that they've been collecting. And finally, something to bear in mind is the importance of accountability. GDPR places responsibility for accountability and for record keeping around data processing upon businesses and therefore upon employers. So prior to going into any kind of new testing or new or novel processing projects that you're undertaking for COVID-19, it's highly recommended, potentially required really, for employers to undertake impact assessments of their proposed processing. You know, what are they intending to do? Why? Can you do it in a less privacy intrusive way? What are the risks? How can you mitigate the risks? So that you've got a record, should there ever be an issue, that you can show to the data regulator to say, look, we have thought about this, we try to mitigate the risks, but also to help reduce your risk exposure as well before going into the processing itself. Thank you.
Thank you, panel. Questions are coming in thick and fast. So first one to you, Daniel. I am going to combine a couple because of the amount of questions we're coming through. What does the government mean by a COVID secure workplace? And how do I create a COVID secure workplace?
It's an interesting concept, is COVID secure, because personally it's misleading. It suggests that there is a way of making the workplace completely safe, which is simply not the case. And the government and the regulators accept there is no way that any employer can completely safeguard against this virus due to its nature. So the term is misleading, but what the government mean when they refer to the term COVID secure, essentially employers need to follow the guidance that is publicly available online. As of the 11th of May, there are currently 8 publications that all relate to different workplace environments. And essentially employers need to consult that guidance and look at 5 key areas. So in the first instance, employers need to be looking at whether their employees can continue to work from home. And if they can, then they must do so at this point in time. If that's not possible, however, and if they have to return to work, then as a start point, they need to undertake a risk assessment. And as part of that process, they need to involve their employees and ultimately, once it's completed, share the results of that risk assessment with their workforce. In addition to that, they need to consider enhanced cleaning procedures, and the guidance is helpful in that regard. It gives some assistance in terms of areas that you may wish to look at. and also social distancing measures, of course, which is really broken down into two parts. Essentially, in the first instance, employees need to maintain a distance of 2 metres. But if that's not possible for whatever reason, then employers are under a duty to reduce the risk of transmission as much as possible. So when you look at that particular question, employers need to ask themselves, well, do we need to carry out this particular task? And if we do, how can we reduce the risk? And the suggestion, the guidance, is measures such as the installation of plastic screens, different working practices. For instance, if you have employees who are working face to face, can you change that so that they're working side to side, back to back, and so on and so forth. So there's plenty of guidance there to employers, but the overriding message throughout all of the guidance is the need to carry out a thorough and detailed risk assessment, because I think the danger as we sit here today, and given the the need for employees to return to work, given all the economic pressures and everything else, the danger is that employees will return to work too early, and that is potentially where employers may be found wanting.
Thank you, Daniel. We're getting quite a few questions on the actual workplace itself, Fiona. I'm going to direct these at you. And it seems to be the case that the employee arrives at work and is actually faced with a temperature check. Some organisations I know are actually thinking of hiring nurses to actually do these types of check. Do the employees actually have to comply with these health checks?
Yeah. I think first of all, you need to look at what the current government guidance is. If we're talking about temperature checks, that isn't something that's currently recommended in the government guidance as something that needs to be done. The World Health Organization similarly says it is something that can be considered as part of your preventative measures, but it's not something that is recommended. So I think if you as a business and you've gone through that risk assessment piece and you feel that you would like to impose temperature checks, obviously you're going to have to get the employees to buy into that, because that's fundamental to being able to carry out the test. And that's where I think the communication piece, which I will most probably say in every single answer today, is so important, because if you're explaining to your employees and consulting with them and engaging with them, listening to them about, what you're doing, how you're doing it, what's it for, what you've done, what risks you're assessing. If you're speaking to them in that way, they will get reassurance. And to be honest, I'm sure a lot of employees will most probably want to do it, and they'll be quite pleased that you as an employer are being so stringent. But of course, that may mean that you get the odd few who feel, well, why is this necessary? Is it an intrusion of my privacy? And I suppose if you do come up against that, what do you then do? I would speak to that person. I would find out what their concerns are about it, and if you can address them. In terms of sending them home or any sort of disciplinary action, firstly, I'd look in your contract. Some businesses have provisions in their contracts or policies regarding testing, i.e. it might be alcohol testing or drug testing. Depending upon the wording, it might be that it is broad enough and that they may be in breach of contract, which you could highlight to them. Also, it's worth pointing out that, of course, we as an employer have a duty in regards to health and safety, but employees have that health and safety duty as well, which Dan can talk more about, but they have an obligation too. So by speaking to them and discussing those points, can you get through to them? If they are in breach of contract, I'd still most probably feel a little bit uneasy in terms of disciplinary action, because I think it is quite a sensitive area. Could we say it's failing to follow a reasonable management instruction? Well, possibly, but I suppose the issue is that employee might say, well, you're asking me to have a temperature check, but I might not be showing symptoms, and still, so is there another way around this? And if there are other measures such as social distancing, etc., surely they should be at the fore of it. So in summary, I think it depends upon your business, your risk assessment. Obviously, clearly in some, working in hospitals, transport, I think the sector is important. But following on from that, get to the bottom of the circumstances as to whether it's reasonable. But I would proceed with caution if you are thinking of going down any sort of disciplinary route and get some advice on that.
Just an added question before I move on to Luke, and I know Dan may want to come back in, was if we were to undertake these checks, is there an obligation to do them in private?
Oh, that's a good question. Well, I suppose you could consult with staff about that. I mean, you could see that certainly employees may feel that they want some privacy in terms of doing that, and so I think that's a view for the employer to take. But I would be veering more so on the side of that, taking into account what the employees' thoughts on that are.
Okay, Dan, did you want to come back in on something? Yeah.
Just very, very briefly, just touching on the point that Fiona mentioned about employees who may be resistant to testing, and employers who obviously want to carry out those tests. As an employer, you may wish to consider reminding employees that they are also under a duty under health and safety law to look after their own health and safety and that of their colleagues, and importantly, to assist the employer in discharging their duties under health and safety law as well. So if there is an element of resistance there within the workforce, then that may be something which employers may wish to consider as a reminder to their employees.
And thank you, Daniel. Now, Natalie, we're in this position where we've taken these checks, we've gathered this data. What are we going to do with this data, Luke?
Thanks, Simon. And I think in terms of what you can actually do with the data, it goes back to some of the themes that I touched upon at the start of this webinar. You need, as an employer, to be firstly transparent about who you're going to share the data with. So setting out maybe in a privacy notice that you provide the employees the recipients or categories of recipient with whom you would share their data, information as to why you were doing it. And you also have to think about whether you have a lawful basis for doing so. So, if it is the special category health data, for instance, as I said earlier, you might well have, obligations as an employer to maintain a safe working environment for people. So you might be able to share it with healthcare professionals, for instance, on that basis. And I also talked about things around, necessity, proportionality of your purposes. These are things that you would have to factor in as well. Do you really need to share it? When you are sharing it, you need to keep that transfer secure. What if somebody missends COVID-19 testing health data? I mean, that could be a very serious breach. So maintenance of security is important as well. So these are all the themes and the factors you need to factor in and think about before you share the data. It is just another form of processing. And these are the kind of things that you should really be factoring into a privacy impact assessment before you then proceed to do it. But the good news is, I think if you do a good, thorough impact assessment, then you will have covered a lot of these bases and really determine whether you need to do the sharing or not, why you're doing it, how you should be doing it, etc. If I may also like to touch upon the previous comments that Fiona was making, and I very much echo those about employees of cooperating with this. I mean, data protection law in itself, GDPR, is not a tool for compelling compliance from the employees. But if you do, can demonstrate to your employees that you've thought about every angle and you're very much complying with GDPR, as Fiona said, it may well help them feel more comfortable to undertake this testing and provide you with their data. And then you'll get higher levels of cooperation in doing so. We also mentioned, should they be taken to one side maybe for a private screening? I have heard of some employers who have been doing this. Sometimes it can be practically quite difficult. But again, if you do your impact assessment around how the test might be taken, it's certainly one of those things you consider. Can we actually take them to one side? Who should be present? Try and limit the people who are present according to their role, etc. So that's another thing you do. But certainly something to consider, I think, would be helpful.
Okay, we're getting a few questions on a few themes and a lot on the employment side. So Fiona, so if we have the scenario that despite the health check and safety measures put in place, an employee refuses to attend to work, for example, because they live with somebody who is vulnerable or is childcare, and we've had a few on because they don't want to take public transport. That's an interesting one. How do you actually manage this?
Yeah, and I think employers are undoubtedly going to get lots of issues with this in terms of the reasons are either going to be I live with someone who is shielding, and so if I've got to go on public transport, I'm exposing myself, and again, lots of people are faced with childcare responsibilities. Not every child is back at school, and there's the summer holidays coming up. School clubs aren't going to be running, so how do we work around that? I think it's about speaking to those individuals, and those anxieties are understandable, and it's about speaking to people. If, for example, it's somebody who lives with someone who's shielding, well, can you look at minimising that in your risk assessment? Can you factor that in? What are their concerns about? If it is the transport piece, well, could we provide them with a parking space? Is that an issue? The government have said that employers should provide more parking spaces if they can, or look at bike racks, look at staggering work times so that they can come on public transport at times when it's quieter and they won't be so exposed. If despite all that it's still an issue, I mean, clearly if they can work at home, I'm assuming from the question possibly that this might be situations where they can't work at home, but if people can work at home, can they do that? Could we redeploy them and maybe work at home for an interim period whilst this is ongoing? I know that's difficult, but if they do have to be in the workplace, how can we alleviate those fears, ensuring that social distancing, because in some that can prove tricky in some respects, but prioritizing those who have those sort of concerns, and ensuring that social distancing, looking at all the options, because we are in a very unprecedented and unusual situation. On the childcare front as well, if we can't look at home working or alternatives for these people, and obviously if you're that there are other options as well. Do we talk about maybe, is there a flexible working pattern that could possibly help? Could they go on unpaid leave? Could they take annual leave? People have got lots of annual leave that's been stacking up. And also remember, for those with children, you can take 4 weeks of parental leave. So is that an option as well? I think it's finding ways to work around this and communicate and engage with your employees. For the few who prove difficult or maybe are being unreasonable, or we have suspicions that they're maybe not being genuine, then I think they have, you go and get advice. But in the large majority of cases, I think we've got to work with the employees to find a solution for them.
Thank you very much indeed. A couple of questions. I'll go to Luke next, and then I'm going to come to you, Daniel. A couple of interesting questions here. For you, Luke, what are the data protection implications of a COVID-19 return to work survey? And is there anything specific you would recommend asking in such a survey?
Thanks very much. Yes, it's an interesting question. I think in terms of surveys, I think most importantly, what concerns people would have, I think, about their data sharing or the data sharing or the data processing, which an employer might want to do. I think again, it could be the survey could be used to drive engagement with the employees. So I think questions that are based around what are your concerns about how you would be dealing with the data, etc. Maybe things that you might therefore be able to address in your privacy notices. Will help, because of course the privacy notice will be the touch point with the employee. So I mean, I would be, I think, focusing questions on maybe trying to gather information about employee concerns around who are you going to share it with, any measures you might use to render it secure, is it going out of another country, and things like that, and maybe feeding that into your questionnaire, because then once you get the kind of the idea of the engagement with the employers, and use it really as a consultation mechanism for your privacy impact assessment, and the questions around practical risks that maybe employers have highlighted, and how you can actually deal with those risks. To what extent do you feel from their responses that it's necessary to do certain things? Because when you do a data privacy impact assessment, it's really a team effort. It's not just the data people or the IT people or the data protection officer in a business. Quite useful to have representation from employees as well. So I would use that as a ground, consider it in your data protection impact assessment, and use it as a basis for feeding information into that, then to produce something at the end which identifies risks or highlights risks that they've identified and then deals with them appropriately. But that will change and be different from situation to situation, of course.
Okay. For you, Daniel, and this may also come back to you, Fiona, is quite a detailed question about social distancing in the workplace. We all know it's 2 meters, and the person asking the question makes a good point that that's great as long as you don't move around too much and there's not too many people in the space. But there's a concern actually that we're all have to use equipment that's photocopiers. It could be wall lights, cupboard handles, etc. And then an interesting one, as in context with this, is there an obligation on the employer to provide PPE equipment, or is that for the employee to provide their own PPE equipment?
Okay, well, thank you for that. In response to the last point, if your risk assessment identifies that PPE is required, then the obligation is on the employer to provide that equipment. That's a long-standing requirement, and that's not changed in the context of this pandemic. Insofar as the social distancing point is concerned, yes, I appreciate it's very difficult to maintain 2 meters, and there will be hotspot areas in every workplace where employees are going to breach that in all likelihood, and there's going to be objects in the workplace such as keyboards, printers, light switches that will be frequently touched. And the answer, and the only way around that, is to deal with that as part of your risk assessment. Identify those hotspot areas, identify those objects that are more likely to be frequently touched, and introduced an enhanced cleaning regime. That is something which is specifically referred to in the government guidance, and it's something which employers all need to be thinking about before any employee returns to work.
Fiona, do you want to add anything to that, or shall I move on to a specific?
No, I don't have anything to add. I think it's the same points from me on that as well.
Yeah.
I think the point here, Simon, is employers have to understand that there is no way they can eliminate the risk completely, and the government accept that. It is all about reducing the risk as much as is reasonably practicable. That is the test in law when it comes to health and safety.
Luke, you wanted to come in on something there.
Well, thanks very much, Simon. And I'm just going back to the question that I was asked about the workplace testing. So I looked at it from one angle as a tool for gathering information about employee engagement and concerns. I suppose another way of looking at that question is, in terms of the actual questionnaire itself and the extent to which that might be invasive, etc. I mean, I think the first thing to consider is, the extent to which you can make the questionnaire anonymous will actually take it out of the GDPR regime, so you don't need to worry so much about data protection issues. The extent that that's not possible, again, I think the watchwords will be things around data minimization. Only collect really what from the employers what you really need from them. Also make sure that the answers and responses are secure as well. Things like that, and provide, maybe if you are collecting data, and it is going to be within the GDPR regime, maybe provide them with a fair processing notice as well to say, look, when you actually are providing these answers to us, this is what we're going to be doing with those answers. So those are other things from if you looked at it from that angle, practical considerations.
Good, thank you. Good question. I feel on this one is in that we are all working from home, and this webinar shows that. So to you, Fiona, to what extent do employers have responsibility for the quality, utility and safety of a work from home environment in the current circumstances, for example, workstation assessments?
Yeah, and I think that it overlaps really with Dan as well in terms of your health and safety risk assessments. You should be doing those when somebody is working from home as well, to identify, we were all thrown into this, weren't we? We didn't, it happened so quickly that we were at home. So I don't think, common sense approach for employers at that time, but this is happening on a longer term basis. So I think employers now have or are in the process of, and I know, again, I'd ask Dan to interject, but I know that there is a health and safety risk assessment on the relevant website where you can go and do that for the home working, so that you can then ensure that the environment is suitable for that person to work in. I don't know if you've got anything to add to that, Dan.
Yeah, I mean, essentially, where it's a temporary measure, then there are no obligations on their employer. But where it is, looking at the longer term, and given where we are today, we probably are in that territory now, then there is an obligation there for those assessments to be undertaken. And employers can easily, and there's lots of guidance on this from the Health and Safety Executive, by the way, but to deal with that, employers can assist employees in undertaking that assessment in their own homes. So, as I say, there is lots of guidance there, and we are moving, in all likelihood, into a time where those obligations are coming into effect on employers.
Okay. I want to take you to an area that is currently in the news and probably will be for the forthcoming months, is track and trace system. I've heard that some organizations are actually looking at a track and trace for their own employees. So a general question, what issues arise for businesses from the track and trace system? Fiona, perhaps I can come to you first.
Yeah, I think this area overlaps between employment and data protection, so Luke may want to have some comments as well about the track and trace system. Obviously, we've got the NHS track and trace system, and those people who are tested positive, they then identify through the contact tracing, and then those individuals are then in a position where they need to self-isolate. The guidance on the track and trace system says, employers have a vital role in encouraging workers to self-isolate and heed the notifications, that it doesn't change the advice to work from home where possible, that they should be on sick pay or use annual leave during that period, and the employers may ask the employer to alert other individuals at work who then may be identified from that. So that's the background to it. Clearly, employers, it could lead to more disruption, but it's less disruptive than a lockdown or a further spike or COVID outbreak for your business. So I think trade unions are worried that employees might not come forward and say that they have been identified, because obviously they're going to be on SSP, whereas they could be on full pay if they remained at work, and that's one concern, and it's a concern for employers as well, that some employers have taken a different stance and said, well, we'll pay them full pay because we don't want the risk of that. Then there's other challenges for employers as well, because if you are identified several times, you've then got to self-isolate on those occasions. You might not have symptoms, so you can't actually go and get a test to get back to work. So that could be an issue for employees. You might have some people trying to abuse the system as well. So there are a whole host of employment issues. And in terms of then taking that's the NHS system, but taking it into, you know, your organisation, and we have heard of some businesses, there's huge data protection issues arising out of that. But you're really going to have to get employee engagement in that process, and for it to work, because it's, you know, it's not mandatory, we're not required to do that. We've got the NHS system. So I think you definitely need the buy-in, and you might get resistance, because employees might say, but I don't see why I have to sign up to this. This is going a bit too far. It might, again, it goes back to that invasion of privacy point. I don't know if you've got anything to add, Luke.
Sure, thanks, Fiona. I mean, I think sort of going end to end on this one, I mean, data protection doesn't prevent per se track and trace occurring. So again, it's a question of complying with the principles of the GDPR. So that the first would be to consider is, you know, do you have a lawful basis for collecting the data that you are collecting as part of the track and trace? And again, as I mentioned, you might have legitimate interests, business interests. You might also be able to capture the special category data on the basis of your employee obligations to keep the workplace secure. In terms of the system itself, you'd want to provide, I think, a privacy notice to the individuals whose data you're collecting, and give them the essential information, or the information GDPR requires around how the track and trace is working, and, you know, the purpose, etc. All the things I mentioned earlier, really. We take care not to collect more data via track and trace than is strictly necessary for the purposes, so minimize the amount of data. And this also feeds into the next point, which is, you know, these systems, you know, need to be very secure as well. So it's, you know, not only per se does it make a lot of sense to make sure the systems are secure, so you don't then become sort of vulnerable to potentially very serious breaches. But of course, the less data you have, the less exposure you have to having to comply or breaches of GDPR. I'd say in terms of track and trace, I mean, one of the issues is, you know, providing information about who might actually have tested, you know, positive. And I think, you know, the rule here in terms of data minimization should be, you know, don't hand out people's names or names of people who actually have tested positive. So don't, you know, share out employee names. I think you just be informing people that somebody has tested positive, and that way you help it be less privacy intrusive for the employees, but also you minimize the data that you're processing. And then, you know, all these factors are the kind of things that you could wrap into your data privacy impact assessment. Really, you should be undertaking before you go into these track and trace projects, because I would think for, you know, quite a lot of businesses, it's either something very new that they're encountering, and therefore as a novel kind of data processing, they should be doing a DPIA, or if it's not completely new to them, they've been doing it, you know, drug testing or other kind of tests for employees before, it will be quite a novel add-on to what they've been doing already. So again, they should consider, you know, building that into their pre-existing structures as well in their data processing.
Excellent, thank you. One for you, Daniel. A lot of questions about if somebody actually contracts COVID-19. So what do I need to do when that actually happens? Do I have to report it to somebody, or?
It very much depends. I mean, COVID-19 as a virus is reportable under RIDDOR, and there is some guidance from the HSE which essentially says that it's reportable in three situations, and I'll cover them very briefly. The first is where there's been an accidental release of the virus in the workplace, and the example which the Health and Safety Executive give is a lab worker who drops a glass containing COVID-19, thus creating an exposure. That clearly isn't going to apply to most workplace environments, but nonetheless it will be reportable. The second scenario is in circumstances where an employee passes away and it's suspected by the medical professional that that's due to COVID-19. It will be reported in those circumstances. And the third scenario, and this would, you know, in my view, would be the most common, it will be reportable in circumstances where an employee has been diagnosed with COVID-19, and note the word diagnosed rather than is suspected to have COVID-19, and there is reasonable evidence that it was contracted in the workplace. Now, the real question here, and I'm afraid this is where the guidance falls down, is what do you regard as reasonable evidence? Is that one employee who contracts the virus? Is it a cluster of employees within a short period of time? I'm afraid there's a distinct lack of guidance there from the regulator on that point. And employers need to think very carefully about that point. And if they decide not to report, then they should record the reasons why, in case they are ever asked questions by the regulator later down the line. Because, of course, if you don't report and the regulator takes the view that you should have reported, then that in itself can be dealt with as a criminal offence. But it's a very, very difficult area, and I'm afraid there's a distinct lack of guidance from the health and safety executive on that point.
Fine, and I know time is getting tight, but I'd like to actually sneak one more question in. I'll kick off with you, Fiona, on this one, but others may want to pick up on it. As far as return to work conversations with employees go, does this have to be done just by HR, or can it be done by line managers, given the potential sensitivity of the data collected? And I comment, quite an onerous task, I'm sure.
Yeah, I mean, not all organisations have HR functions, so they might only be in an instance, and you know, you've got to have, I suppose, there's got to be that confidence there anyway. If it was dealt with, I mean, I think it can be dealt with by either, because, as I say, some organisations don't have that HR function there, but you know, even with your line manager, there is that trust and confidence there. There is that expectation of confidentiality. So I think, you know, that is, but I think you've most probably got to be very clear with your managers in terms of how those conversations are conducted, being mindful of the sensitivities, seeking further advice, etc. Because you're potentially going to get a whole host of different questions posed, etc., concerns raised, and it's being able to respond to those.
Anybody else want to pick on that? Because if not, I'm going to squeeze one more in.
I just got one comment. So I agree with Fiona. I mean, I think, you know, potentially either those types of person, you know, if appropriately trained and, you know, complying with appropriate GDPR principles and requirements could conduct that, provided it's, you know, sort of thought about in advance and appropriately structured. I just think the key thing is you know, that's okay up to a point, but there may well be, you don't want to overshare and you want to minimize the data shared around the business. So there will become a point where, you know, I don't think you can just necessarily, you know, have these conversations with anybody within the business. And so, you know, there is a line to be drawn, and consider, because it might be harder to justify to a data regulator if actually you've had a conversation with someone who's just, you know, shouldn't really be hearing these kind of these conversations. But I think certainly, yes, line manager and HR would be the kind of persons who would be appropriate to have this type of talks.
Okay, so the last question, we've just got enough time to squeeze this in, and I'll kick off to you, Fiona, but I'm sure Daniel will want to come in on this. What should an employer do if a colleague refuses to follow the risk reduction COVID-19 procedures?
Well, I think, you know, reminding them in the first instance of what the procedures are, that you've done your, you know, your risk assessment, the importance of this. Some employers have now put in place COVID-19 policies, so that they clearly set out the expectations, and that obviously if it's not followed, it may lead to disciplinary action. And I would, you know, bearing in mind you as an employer have obligations in relation to health and safety, reminding the employee also about their obligations. And I think you would do it as you would any other disciplinary matter, in the first instance informally, saying, let's just go over the rules again. We do need you to adhere to this. It's important for these reasons. And, if it happens several times, saying we've had several conversations about this, and if it happens again, I may have to consider whether disciplinary action is appropriate. And ultimately, I think you would go down that route if someone is repeatedly and willfully disregarding the instructions, because it is very important that we adhere to this. If you didn't do that as an employee, you could certainly get other employees saying, why aren't you addressing this? This is a risk in the workplace. I don't feel comfortable coming in. So you've got to think about your responsibility to your other employees as well, and the issues that can arise out of that. Dan, I don't know if you
just very briefly, but you touched on it there, Fiona. From a health and safety perspective, as an employer, all you could really do was remind them of their own obligations under Section 7 of the Health and Safety at Work Act, which is to essentially look after themselves and their colleagues and comply with the employer when they are trying to discharge their own health and safety responsibilities as well. And of course, if they don't do that, then, as you say, Fiona, it then becomes a disciplinary matter. But I think there's another important point here, and there's a distinct lack of any reference to it in the government guidance, which all talks about risk assessment and enhanced cleaning procedures and social distancing. But what employers must not forget is, of course, the need to monitor the effectiveness of new working procedures, because that's also a responsibility under health and safety law. It's a long-standing responsibility, and nothing's changed in the context of this pandemic in that regard. But it's something which the guidance doesn't talk about. But it's something which employers should be mindful not to overlook.
Indeed. Well, thank you for that. May I take the opportunity to thank you all for joining us once again. We've had over 150 people on the webinar today. So a special thanks to our panel, Daniel, Fiona and Luke, for being so informative. Big thank you from me to Rebecca Pearson in my team in being such an influential catalyst in pulling this together as always. And just to reassure you that we have had a lot of questions. There are many unanswered, but we will be following up, and they will all be followed up by the panel over the next few days. We've also recorded this as well. You'll be getting a copy of the recording. But please stay well, keep safe, and once again, thank you for joining us.